Every once in a while comes a general purpose technology that changes everything. At the turn of the 20th century, it was electricity. Today, it's artificial intelligence. AI has been hailed as the next industrial revolution, and the changes are happening before our very eyes. My name is Helen McFadzean, and I am a senior associate with Phillips Ormond and Fitzpatrick. Today, I'm excited to be talking to you about patenting AI inventions in Australia. So the provision governing patentable subject matter in Australia is Section 18 of the Australian Patents Act. And under Section 18, an invention is a patentable invention if the invention is a manner of manufacture within the meaning of Section 6 of the Statute of Monopolies. This manner of manufacture requirement is often referred to as the requirement for patentable subject matter. There is something a bit circular in the way that this matter is dealt with under the Act. There is no explanation of what is meant by the term manner of manufacture apart from this reference to Section 6 of the Statute of Monopolies. And the same reference is repeated with some slight variations and additions in the definition of an invention in the dictionary in Schedule 1. The Statute of Monopolies was passed by the English Parliament in the year 1623. So the law regulating the latest technological innovations is in part based on words written about 400 years ago. So you can imagine why we might be getting some problems today. The meaning of manner of manufacture is not specifically defined under the Act, and it has evolved over the years with case law, particularly in the area of software implemented inventions. Now, let's have a look at the case law, starting from the very beginning. In this decision in the year 1959, National Research Development Corporation, NRDC, and the Commissioner of Patents. This decision was a bit of a landmark decision on manner of manufacture. It's a decision from the High Court, which is Australia's apex court, and the decision has achieved iconic status in Australian patent law. The invention was in relation to a new method of applying known chemicals to the soil to eradicate weeds. The chemical was known, but never used in this particular application. The court considered that the previous requirement for there to be a vendable product was too narrow, and that this method of eradicating weeds should be considered patentable subject matter because it produced a useful effect and offered an advantage, which was material. There was an artificially created state of affairs. The process belonged to the useful arts as distinct from a fine art, and the method was in the field of economic endeavour. This case effectively broadened the definition of manner of manufacture and paved the way for a number of favourable court decisions during the PC revolution of the 90s. So in the year 1991, in this decision, International Business Machines and Commissioner of Patents, the invention was in relation to the use of a mathematical formula in a computer to produce an improved curve image. The court considered that this invention has satisfied all of the NRDC tests and should be considered patentable subject matter because it involved steps which were foreign to the normal use of computers, and the production of the improved curve image provided a commercially useful effect in computer graphics. In the decision CCOM and JGing, the invention was in relation to a method of retrieving Chinese characters from a database that encoded the character strokes by stroke type and in an order in which the strokes are written. The court considered that the use of word processing to assemble text in Chinese characters was considered an artificially created state of affairs of utility in the field of economic endeavour, and that there was a physically observable effect in the retrieval of characters for the assembly of text. So this was also considered patentable subject matter. In the next decision, Welcome Real-Time and Contuity, the invention was in relation to the particular use of an electronic smart card in customer loyalty schemes. The court considered that there was a physically observable effect in the writing of new information to a file and the printing of a coupon concerning the operation of smart cards in connection with loyalty programs. So this was also considered to be patentable subject matter. In 2006, in this decision, Grant and the Commissioner of Patents, the invention was in relation to a method for structuring a financial transaction to protect an individual's assets. There was no computer implementation at all in this invention, and the court considered that it was unpatentable because it was directed to a business method, and that in order for there to be considered patentable subject matter, there needs to be a physical effect in a sense of a concrete effect or phenomena or manifestation or transformation. I remember the good old days when these were the only requirements that we needed to satisfy in order to satisfy the requirements for manner of manufacture. And essentially all you had to do was claim that the software method was implemented on a computer and it would immediately meet all of these requirements. In about the year 2010, the Australian Patent Office started to clamp down on their examination of computer implemented inventions. And in 2014, the High Court handed down the decision Research Affiliates and Commissioner of Patents. And this marked the start of a number of changes in which effectively narrowed the definition of manner of manufacture in Australia. The invention was in relation to a method to create a securities index by means of a computer. The specification made very little reference to the computer, even though the computers were limited to a computer implemented invention. In some of the embodiments, it was even described that an analyst may use the computer to generate the index. So the court had to decide whether this essentially a business method claimed as a computer implemented method will be considered patentable subject matter in Australia. And they said that the previously applied NRDC tests were no longer sufficient or exhaustive. They are relevant, but not conclusive. They also introduced this idea of a substance of the invention. So the invention is construed based on the entire specification and not just the words set out in the claims. So the invention is to be understood as a matter of substance and not merely as a matter of form. And in this particular case, after considering the substance of the invention, the court found that ingenuity in the invention, which was to do with the method to generate the securities index, was in the scheme and not the computer technology. And for this reason, they found that the method was not patentable. And the mere implementation of an abstract idea in a well-known computer would not be considered to be patentable subject matter. Darcy and Myriad, this was a High Court decision, the High Court being Australia's apex court. In this decision, the court affirmed this notion of a substance of the invention, so construing the entire specification to determine the substance when considering the question of manner of manufacture. This particular decision was in relation to information stored in the nucleic acid sequence coding, which the court found to be the substance of the invention, and this was the same as that contained in the DNA of a person from which the nucleic acid is isolated, and was not made by human action, and therefore was considered to be not a manner of manufacture. In Commission of Patents and RPL Central, the invention was in relation to a computer implemented method for assessing somebody's qualifications for recognition of prior learning. And the court considered that there needs to be creation of an artificial state of affairs where the computer is integral to the invention rather than a mere tool in which the invention is performed. The court also said where the claimed invention is to a computerized business method, the invention must lie in that computerization. It's not a patentable invention simply to put a business method into a computer to implement the business method using the computer for its well-known and understood functions. It is necessary to ascertain whether the contribution to the claimed invention is technical in nature, and there needs to be some ingenuity in the way in which the computer is utilized. Simply putting a business method or scheme into a computer is not patentable unless there is an invention in the way in which the computer carries out the scheme or method. In this next decision, Encompass and InfoTrack, this was a fairly highly anticipated decision at the time because it involved an expanded full bench of 5 judges, and both the Australian Patent Office and the Institute of Patent and Trademark Attorneys in Australia sought leave to intervene in the proceedings in the hope that this decision would provide some more clarity in this area. The invention was in relation to a computer implemented method for displaying information relating to entities to provide business intelligence. Unfortunately, the specification did not describe the computer implementation in very much detail. It simply said that the process system is suitably programmed. This led to the finding that the computer implementation was generic, and the court essentially confirmed the requirements set out in the previous decisions in Research Affiliates and RPL Central, and reiterated that patentable subject matter is not provided simply because the method is a method in an electronic processing device, which itself is not characterized. In this next decision, Commissioner of Patents and Rocked, the invention was in relation to a digital marketing scheme, which the court referred to as clickbait. Um, the court essentially confirmed the requirements set out in the previous cases. But in addition, they clarified a couple of things, and these are that the question of construction, construing the specification to determine the substance of the invention, that is a legal question for the courts and does not lie in the realm of facts. In the primary judge's decision, the primary judge had relied quite heavily on expert evidence, which led to a finding that this digital marketing scheme was considered patentable subject matter. And the full court overturned that decision, saying that it should actually be a legal question for the courts, even though expert evidence can be helpful. It is not a question solely in the realm of facts. And they also clarified that common general knowledge, which is the general body of knowledge taken to be background knowledge and experience that is available to everybody in the trade, this is to be relevant for construing the specification only and not to be used for a pseudo inventive step analysis. And this was in response to the issue that there is some conflation between the consideration of manner of manufacture and inventive step in Australia. In the most recent decision, Commissioner of Patents and Aristocrat, the invention was in relation to an electronic gaming machine with a particular feature game. The court posed a couple of new questions, and these are whether there is a computer implemented invention, and if so, if there is an advance in computer technology. Now, this decision is currently under appeal to the High Court, and we are expecting an outcome later this year. There is some commentary at the moment about this requirement for an advance in computer technology and whether or not that is too high for a subject matter eligibility test. So based on all of this case law, the Australian Patent Office compiled a list of questions for the assessment of manner of manufacture. So first of all, we must construe the entire specification to determine the substance of the invention. And then the office goes through this list of questions to determine whether the computer implemented invention is in substance a manner of manufacture. One thing to keep in mind whilst considering these questions is that most of these questions are based on case law on computer implemented business methods. So there's no technical application outside the computer, which is why I think these questions have a heavy focus on the computerization and the computer implementation part of the invention. There's also a little bit of overlap in the question. So for example, this one, if there is ingenuity in which the computer is utilized, then the computer implementation is probably not generic, and the computer is probably not merely an intermediary or tool for performing a method without adding anything more. I think, though, the key question is this one. Does the invention solve a technical problem within the computer or outside the computer? If the invention is solving a technical problem outside the computer, then the machine learning algorithm may be applied to another technical field, for example, may be used in a medical application or control system for controlling an industrial process. If it is solving a technical problem inside the computer, then, for example, the machine learning algorithm may be applied to the field of quantum computing. It may be solving a problem in relation to memory allocation or taking into consideration the computer architecture. Since this is a fairly new area and there's not a huge amount of case law, I thought it might be useful to have a look at some recently accepted Australian applications in the G06N class, being the classification for AI and machine learning related inventions. And the first application I have here is in relation to quantum computing. So quantum computers provide more computational capacity for certain types of difficult problems. And in quantum computers, computational tasks are performed by implementing sequences of quantum gates. The faster the quantum gates execute, the more computational capacity there is for the quantum computer. There are some obstacles for realizing fast, high fidelity quantum gates, and these include things like leakage errors or quantum hardware control noise. And you can think of these errors as errors to do with the hardware of the quantum computer. And in this particular invention, a classical processor is used to design a control trajectories for implementing on the quantum gates to reduce errors and noise. And claim 1 is directed to a method for designing a quantum control trajectory on quantum computing hardware using reinforcement learning in order to minimize the errors and the noise. This would be considered patentable subject matter because there is a technical contribution in the use of reinforcement learning to control the quantum gates. It solves a technical problem within the computer in the reduction of errors and noise associated with the quantum gates. There's ingenuity in the way in which the computer is utilized. There is an improvement in the functioning of the computer, irrespective of the data being processed, being the fast execution of these gates to improve computational capacity. And it can be broadly described as an improvement or advance in computer technology and involves steps that are foreign to the normal use of computers. The second example is in relation to autonomous vehicles and the use of machine learning to provide a navigation path for the autonomous vehicle for delivering packages. Claim 1 in this application is directed to a computer implemented method that determines the navigation path using an artificial neural network that has been trained on similar path. The artificial neural network receives sensor input and information regarding locomotive capabilities of the vehicle, and the vehicle can receive remote assistance depending on a determined confidence level associated with the path. And this particular example solves a technical problem outside the computer. So I thought this was a good example to give in conjunction with the previous one. The previous one was in relation to solving a technical problem within the computer, and this example is to do with solving a technical problem outside the computer. And in this example, the technical problem outside the computer is in relation to the navigation of an autonomous vehicle, um, which may include, for example, some unpredictable or uneven terrain, for example, going up some steps here. And it provides a technical solution and contribution that creates a technical effect in the use of neural networks to determine a navigation path and a confidence level for remote assistance when required. There's also a practical and useful result in the delivery of packages using an autonomous vehicle. And finally, just some takeaway practical tips. So in Australia, we have this focus on the specification. So drafting is really key because the invention is to be understood as a matter of substance, and we need to consider the substance of the invention when looking at the specification as a whole in light of common general knowledge, and not just the words defining the invention in the claims. It's also important to consider during drafting whether the invention solves a technical problem within the computer or outside the computer, and whether there is a technical contribution um, for the invention. And once that is properly understood, it is important to describe the technical problem and the solution in sufficient detail in the specification. It is also useful to provide as many examples of different technical applications as possible, and this can help support a case that the substance of the invention is technical in nature um, rather than non-technical. I would also caution when using terms like any combination of hardware and programming can be used to implement the functionalities of the respective elements, or any suitable processing system may be used in the specification when describing the computer implementation. These throwaway lines can often be used to try and broaden the scope of protection, but it can be often picked up by the examiner as an admission that the computer implementation is generic. I hope you've enjoyed that short snapshot of patenting your AI inventions in Australia. If you have any questions, please feel free to send me an email or connect with me on LinkedIn and shoot me a message. I'm always happy to talk about AI or patents or both. And I will be very happy to hear from you. Thank you.